Welcome Clarence, Amameda, and Arpi, Sepanian, both Ownership Services Supervisor in Ownership Services. They will discuss Proposition 19 and what to do upon the death of a property owner. Welcome.
Good morning. My name is Arpi Sepanian.
And I'm Clarence Amameda.
We are managers in Assessors Jeffrey Pran's Ownership Services Division. This morning, we want to share some information on two topics that impact homeowners and families. First, we'll discuss Proposition 19.
What is Proposition 19? In November 2020, a ballot measure dramatically changed the exclusions available for family transfers. These are intergenerational transfers where parents transfer their home to their children, or vice versa. And in some cases, transfers between grandparents and grandchildren. These measures also changed the property tax relief available for seniors 55 years of age and older, the disabled, and victims of wildfire and other governor-declared natural disasters. The Proposition 19 parent-to-children new exclusion rules took place as of February 16, 2021. Only the home that the parents or children live in can qualify for property tax relief. This new requirement means the parents must live in the house and that at least one of their children they transfer their home to must also live in the house. And the child must claim the homeowner's exemption exclusion. So if you own a building you use as a retail store or other business, and you transfer it to your children as of February 16, 2021, the property will be reassessed at the full market value, which is the price it would sell for, and the taxes will increase. Also, if you transfer a home or a duplex to your children and they do not move in, it will also be reassessed at full market value, or what you could competitively sell it for in the open real estate market. The new law also limits how much value can be excluded from your home. If the home value is more than $1 million, the property taxes will probably increase some. There is a calculation to determine by how much. So to receive the exclusion benefit, if you transfer your home to your children, first, they must file a Proposition 19 exclusion claim form. Then they must move into the home within 1 year and file for homeowner's exemption or disabled veterans exemption. If these filing deadlines are not met, prospective relief may be granted in some cases. But to receive the maximum relief, all of the criteria I mentioned must be met. If they later move out, the exclusion will be removed, and the property's assessed value will be increased. We can provide more information and answer specific questions at our resource table. So Arpi, can you tell us more about Prop 19 relief?
Sure. For the senior, disabled, and victim of wildfire or natural disease relief component, base year value exclusion, it became effective as of April 1st, 2021, and it expanded the benefits. It allows the owners to transfer their property tax value to any county in the state, provides the exclusion up to 3 times, allow owners to buy up to purchase homes that cost more than what they sell. If the home you purchase is more than the home you sold, the value difference will be added to your old property tax assessment base. But if you qualify, you're not assessed at the full market price for which you purchased your home. Our website has a calculator that helps you estimate your new assessed value for these types of base year value transfer exclusions, and for the family transfers Clarence discussed earlier. If you're a senior, you will need to provide proof of age, and other documentation also may be required based on the type of exclusion you're requesting. None of these exclusions are automatic. You must apply for all of them by completing the correct form. The forms are available on our website, and our office has to review and approve them. Clarence, can you now share some information on what needs to happen when someone dies and they own a home property?
Absolutely, thanks Arpi. Although this may be a difficult time for family members, Most people do not know when the property owner dies, the person responsible for handling their affairs, their spouse, their executor, or successor trustee, needs to contact our office and complete the change in ownership statement, death of real property owner. A death of an owner is a change in ownership. It is essential to remember that our office needs the person responsible for handling the decedent's affairs to notify us timely within 150 days of the property owner's death. Submitting the change in ownership statement, death of real property owner form is very important because timely notice ensures that our records are updated and reflect the correct ownership. It also may prevent tax penalties and escape assessments, which may result in the generation of a lot of tax bills for several years at one time. Notification is even required, even if the trustee dies, if it is held under the trust, if there's a will, if there's no will, or if the property is in probate. You still have to file the change in ownership statement, death of real property owner. So Arpi, do you want to add some more?
Yes, and if the person receiving property qualifies for an exclusion, there are specific time limits that they need to meet to get the property tax relief. Again, not filing on time may result in higher taxes and penalties and a denial of an exclusion claim. If you have a specific question, please visit the resource table and our team will be happy to answer them and to make any referrals. Thank you.
So we're opening the floor for any questions here from the audience. Yes, go ahead, sir.
Yes, if the husband and wife,
if the husband and wife got a divorce, does that mean that the residence of the husband can be passed to one child and the residence of the wife can be passed to another child, assuming they have different residences?
Well, for that particular example, both husband and wife should be eligible for homeowner's exemption, so which means that both husband and wife should have established that the property was their principal residence. So, and then if it gets transferred to one of the kids or two other children, then one of the child should be claiming homeowner's exemption, and that property, they should be living in that property within 1 year of the transfer.
it's two separate properties.
Oh, is it?
When they get divorced, the husband lives in one and claims homeowner's exemption for that. And
Oh,
the
yeah, that's
second
fine.
Property, the wife claims a
Right.
principal residence, so now each of them can
I
pass it
see.
to two kids now individually.
Exactly. As long as it has been established that the transfer is principal residence, and both children or whoever's getting that property will also apply for homeowner's exemption within the 1 year of the transfer, then they're good.
What is the what's the exclusion for senior citizens?
It's Proposition 19 base year value transfer.
So what if you don't get anything extra for a senior citizen, right? Like if you were
Well, the purpose of the base year, if I may interrupt you, the purpose of the base year value transfer is if you sell your house that you live in and you purchase a house, you may be able to transfer, and if you're over 55 years of age, then you will be able to transfer your base year value from your old house to your new house.
Which means you won't get a tax increase if it's of equal value.
Exactly.
What's a probate?
Probate, if the property is not held in a trust, if the property is just held under, let's say, Clarence and Amameda, it's not in a trust, just an individual name, and if I pass away, it has to go to probate, and there's no will, you still have to go to probate.
I know, but what is it? What do they do? What's the procedure? What is that?
Well, you have to file probate documentations at the probate court once someone passed away.
I know, but what do they do? What's up?
Establish the heirs of the property.
Okay.
Hi, good morning. I'd like to know when a person passes, like my mom, and me and my sister's name was already on the property. Anyway, I want to know, since our names were already on the property, do we have to pay higher taxes?
Was mom originally on the title, or just you and your?
All three of us.
All three of you guys? So if all three of you guys and mom is transferring to you and to your sister, or how?
We just dropped her name.
Oh, okay. Well, if the property was reassessed due to removal of mom's name, then you may qualify for Prop 19 relief as long as all the criteria are met.
Thank you.
One more question over here.
Morning. My father recently passed away, and an adult son was living with him for the last year and a half. The property itself, they were living in a two-bedroom home, and in the back of that there was a triplex. However, they haven't been living in that triplex for the last 25 years. It's been more just like storage. So now that my father's passed away, the house was the property's in a living trust. What, I don't know if I'll be able to apply for anything regarding tax-wise, or what would happen in that situation?
We can check your, your qualification for Proposition 19. We need to review, we can see the book
Okay,
to give you more detailed information on that.
all right, thank you.
Okay, we have a room for one or two more questions.
In the case of a parent, when they pass away and the child moves back to the house, they have a year to move back, and you say that they would qualify for the, I guess, avoidance of increased taxes or reassessment. What is the time limit? Like they have to be there at least a year or indefinitely?
The children must, sorry.
Or not getting reassessed on the taxes. So if the child is not living in the house, but I understood they will need to be back in the house within the year, so for the property not to be reassessed, is there a limit that they will, or if they decide to move away, not to stay just a year or 2 years in the house? Is there a limit in that? Their time?
Well, we just have to establish that whoever is living in whoever is going to move in that property, for example, the child must live within 1 year from the date of transfer. Now, if should they move out, like what I've said earlier, then the property will be subject to reassessment, because ultimately what we want to establish here is the transferor, which is the parent who's transferring the property, used to live in that house or still live in the house, and the transferee, the child who's getting that property, should be living in the house and have homeowner's exemption. So there is a possibility that if that child moves out, then the property will be reassessed because they're no longer living in the house, per se.
My question is, like, if they move out, let's say, like, within 2 years after they're living in there, if they move out 2 years, 3 years later, because they have to be transferred to a job, let's say,
Reassessed. Property will
so
be
it doesn't
reassessed.
matter how many years they live in, it will be
Yes.
reassessed.
The children would need to live in the property.
So if a child moves in and they stay there, they get in there within the year, they live there for 3 years, and there's more siblings, could another one come in behind that one?
Yes, the sibling must file homeowner's exemption.
So if there's 6 children, you do it 6 times.
We have to have that homeowner's exemption placed on the property.
That's fine, but it could be done.
Yes.
And that's the way the law was written. So we're just doing events like this to make sure we educate the public. And we have room for one more question.
Yeah, I know nobody likes to pay taxes on, especially on the property, or any taxes, in my opinion. Okay, couldn't we just, instead of like say, yeah, I do want your business card after, but say if I cannot qualify for that Proposition 19, why don't I just do a tax deferred 1031 exchange and avoid the taxes?
That's something that you have to seek legal advice, sir. But, if you do wish to go that route, we would highly recommend for you to get legal advice if that property will be subject to reassessment.
Because once you do the deed, once you transfer the title to your name or to whoever, it's not guaranteed that it will be or it will not be subject to reassessment, unfortunately.